Mr. Deputy Chairman, sir, even though this bill is significantly technical in nature, I'm extremely grateful to a very large number of honourable members who have spoken on it, predominantly out of concern towards the health of the banks, the large NPAs, and in order to see that firmness coupled with fairness is maintained in the process of recovery of these outstanding loans. So let me at the very outset say that the government is fully committed to preserve and maintain and strengthen the health of the public sector banks because they've had a very important role to play in the economy of this country. When a large number of us use the word loans, loans being given to large industries, loans being given to individuals, I don't think giving loans itself has anything negative about it. Banks are supposed to give loans. Economic activity, whether it's trading, industry, building a house, educating yourself, helping yourself as a farmer, all this survives on the strength of bank credit. So if banks start squeezing the loans, there will be no economic activity left. In fact, one of the measures of an economy doing well is if the credit offtake from the banks increases, which means a lot more economic activity is taking place. So loans are a good thing. Loans are not a bad thing for the economy. Nobody sets up an industry by bringing 100% of his own capital out of his own pocket. And in a country like India, which is still a developing country, availability of capital is scarce. After all, how many conventional business houses were there for centuries who had their original capital? A lot of entrepreneurs who after 1991 have come up have really managed to create some capital of their own, and then on the strength of the debt that they get from banks, they have set up businesses, industries, etc., and some of which have been highly successful also. The cause of worry is when these loans become either non-performing assets or they become stressed assets, or the activity in which these loans are invested itself is not generating money enough. Now, it is true that in some cases, and these would clearly be cases of misdemeanor and misconduct, where a bank has given a loan to a person who should not have been given a loan, or it is given for a wrongful purpose. That would not only attract civil liability, that would also attract criminal liability. But I think one of the pertinent points which Mr. Subiram Reddy made while opening the debate, where he said that in some cases there would be a willful default. A willful default is of a person who siphons out money. A willful default will be of a person who has money and assets lying concealed somewhere, but is not paying back. These cases will have to be distinguished with cases where, even in the context of large industry, just as some people mentioned the cases of farmers and students, where the economic environment itself becomes adverse, and therefore on account of adversity of economic environment, an industry is unable to pay the loans back. Now, the world has been facing a global slowdown, and one of the aspects of the slowdown is that there is low demand worldwide. Now, that absence of demand is impacting globally various sectors. Similarly, in India, even though we didn't face the kind of slowdown which the rest of the world has faced, we face certain specific problems in relation to certain select sectors of the economy. And this large NPAs that we are speaking about, first of all, let us be clear. I said in the morning also in reply to a question Generally, people who take small loans are returning the monies back. So microfinance in India is one of the most successful modes of financing, where small industries are financed, small businesses are financed, household industries are financed, and the recoveries are very high. The mudra loans, people take loan one day and go and return another day, they take it back on the third day. The recoveries are very high, and that is why the whole cycle of loans is working quite well. There is some problem with regard to farmers in some cases, but then banks are also compassionate enough, because these loans are not very large. And therefore, time-bound extensions, etc. are given. And hopefully now, with the support of a crop insurance scheme, where the premium is very minor, because states are subsidizing the premium, and the recovery from the insurance is going to be very high, I think a part of the problem would be addressed. World over, students educate themselves on the, particularly in higher education, on the strength of student loans. In India, this trend has picked up to a little extent. There are NPAs in student loans, but then the suggestion which was made that these loans will be referred for securitization, etc., because these are not supported by any securities. So you will go for securitization action only if there are supporting securities. So securitization really never gets attracted as far as student loans are concerned. One concern which was expressed was, what happens to the farmers? The securitization law very clearly states that securitization does not apply to agricultural land. Therefore, as far as students and farmers are concerned, our fears may be somewhat exaggerated. The problem of bad loans is, and I've said this earlier, so I'll in brief just repeat it. We had a largest single NPAs were in steel. That's a core sector. And that was because cheap, low-cost Chinese steel was coming into India. We have taken certain actions, and there is a revival which is seen in the steel industry. If this revival continues for some more time, then this loan becomes bad, because the companies are running. They are manufacturing steel, but their demand was low, and they were neither able to service interest nor pay back any part of the principal. That is when a technical entry is changed, when for 90 days you have not serviced that loan, that from a performing asset which is generating interest, you became a non-performing asset. So steel was a major sector, power was another sector, and in power, one of the contributors was not only the private sector power companies, because power demand was low. The cancellation of the coal blocks also led to sickness in the power sector, but also because a series of state discoms had very bad health. They were not charging the consumers the market price, and instead taking loans from the banks. And those loans which are owed to the state companies, after steel became the second largest contributor to the NPAs. So when we are speaking in terms of NPAs, it is not only private sectors and big industries, it was also the state discoms which have contributed to a large section of these NPAs. And these NPAs of state discoms are also not in thousands of crores. Collectively, they had gone into lakhs of crores. There was a problem in the highway sector. There was a problem with infrastructure. There was a problem in the textile sector. Now, these are sectors which were all impacted by various factors, domestic or international. Few of them have revived. And now the effort is, and that's the choice the government has, and the banks also have, the moment it's an NPA, do we immediately close that industry? What happens to India's industrial development then? These may be temporary economic trends. These are economic cycles. The cycle may change, and therefore a revival takes place. Do I restructure the loan, give it some more oxygen and allow him to revive the industry? Or if I find that this company is not able to revive, do I ask him to induct another partner? Should then the banks take over the management? Should they completely oust this management in the case of a willful default and put somebody else in? And if a particular group has 5 industries, Could the banks now ask them to liquidate, sell one of them to a new person, get the money and liquidate a part of the debts? Now, these are all different instrumentalities which are administrative in nature, and through a series of guidelines, you have the corporate debt restructuring, you have the SDR mechanism, you have the JLF mechanism with the banks, and where the banks have been given considerable amount of flexibility by the Reserve Bank in order to make sure that the industries revive, because that's the preference in a larger national interest. And after the revival of these industries, these companies are in a position to pay back the loans. All these activities in relation to various loans are on. Then comes the next question: how do you legally strengthen the banking system so that against those who persistently default, the bank is able to recover those monies? Now, one of the mechanisms which we created, which was a modern mechanism, was the bankruptcy law. We repealed all our earlier Provincial Insolvency Act, the company law provisions relating to commercial insolvency because of inability to pay debts, and instead now have a comprehensive bank insolvency and bankruptcy code in the country. It's a modern law, it's internationally compatible. The moment a company is sliding down, the banks will intervene, and therefore there are various revival methods. There are various instrumentalities which are created by the banking system. Eventually, the management either continues or the management goes out and the assets of the company are saved. That's the last resort, but these are all powers under that law which we have passed in this Act. What is the purpose of the present set of amendments? Originally, if the bank was entitled to recover its dues from any person, it used to move to a civil court. This was an ordinary litigation where all the provisions of the Civil Procedure Code used to apply, and you would stand in queue as a banker before the civil courts. Now, the civil courts were found to be a time-consuming experience, and therefore in the year 1993, we had the Debt Recovery Tribunal mechanism which was created. The DRTs were created, and the appeal from the DRT used to lie to the DRAT. It was a special court. The provisions of the Civil Procedure Code and the Evidence Act didn't apply except for the specific procedures which were mentioned. And the whole object was that the DRT would expeditiously dispose of these cases. I think my friend Vivek Tankha was right when he said that the infrastructure was poor. There were issues of members, there were issues of vacancies, and all the procedural factors that he mentioned. Now, what are we trying to do by the present amendment? Out of the 5 DRATs, you said 4 were lying vacant. Today, 4 are now have chairpersons, and it's not a very easy thing to get a chairperson. A High Court judge retires at the age of 62. You offer him a job at the age of 63, which goes up to 65. In some cases, you have to dislocate his city at that age. Now, the recommendations which were made, in the 5th case, the gentleman has refused to join. So now we've again referred it back to the concerned Supreme Court judge who was chairing the committee. So if we can request somebody else to go to Chennai. As far as Delhi and Mumbai are concerned, the appointments have been made. I am told Delhi has already taken over and Mumbai will take over. Similarly, in DRAT also, most of the positions are occupied. There are some vacancies which we are trying to fill up. The object now is that the 1993 object got defeated because DRT and DRAT became like any other court. Arrears, inefficiency, and so on. Now what we have proposed is that these are all banking institutions, and the mechanism of lok adalats for small loans, supposing somebody owes 2 lakhs or 5 lakhs, then the bank is not going to waste his energy going to DRT, etc. These are all settled through lok adalats, etc., thousands of cases are settled. You give and take something and then make some concessions and then settle the amount. Now the object is that DRTs will be intended to be electronic courts. I think we have to be clear in our approach. There has to be fairness, but there will have to be firmness. So when Vivek says, why should a man first vacate his house under Securitization Act? It's only when business people who are willful defaulters, when they have to vacate their house, that they pay. Otherwise, if you provide him the special facility, that you continue to live in your house and continue to enjoy your factory, and then keep litigating by engaging Vivek Tankha in the Supreme Court. And this is what has happened. The most controversial case going on of the person who hasn't paid and has now moved on to London, I only hope that the State Bank of India one day comes out with the kind of litigation that the State Bank of India and other bankers had to contest. It's not in 5 or 10, it's in hundreds. And the kind of unusual facilities which were given, even by the apex court when they said, even in a hearing for a willful defaulter, don't take it as a precedent, but for this particular person, allow his lawyers to represent him. The banks never allow lawyers to come up in the hearing on willful defaulter. What was so special about him? The whole object of the DRT, therefore, is, what are the kind of defenses, please tell me, that in a bank recovery case that people take up? Which is the last bona fide defense that you came across? Except delaying, then compelling the bank on its knees, and you settle for concessions. And then, when the health of the bank becomes bad, in the last 2 years, I have had to take out 50,000 crores from the union budget to support the health of the banks already. Now, 50,000 crores put into irrigation would have done far greater advantage to India. But we put 50,000 crores because some of these people have reduced the banks to this situation, and therefore I don't think we should think in terms of allow him the privilege of continuing to occupy his house under Section 14 of the Securitization Act, and then he can litigate. It's only when he faces the humiliation of sitting outside his house that he will settle. Now the procedure is, the bank will file its claim online, the reply will have to come online, the documents will be filed online, there will be 2 hearings, one for an interim order, one for a final order. The lawyers may not like it, but at the end of the day, in 180 days, the DRT has to decide whether the money is payable or not. And if you want to file an appeal, pay at least 25%. Now, Vivek finds something wrong with 25% being paid. Well, I think public interest is suffering harder. Kindly appreciate if 20 people, I can tell you 20 people are sitting on bank monies so that the banks are not able to support 20,000 others. Now, all 20 will say we are hard cases, but aren't those 20,000 cases who want to run businesses on bank support also hard cases? Now, when you took the money, your monies are taken with under the honest arrangement that monies will have to be repaid back. So, if you want the facility of an appeal, if your appeal is not merely a ploy to delay, then please pay 25%. Sell some of your assets. You can't have a situation that till the day you get a loan, you work day and night for it. The day you get a loan, the bank manager has to keep awake and you sleep well. This principle needs to be reversed in India. And therefore, the DRT amendments are intended to create this new procedure so that recoveries in DRTs become easier. Why was the securitization bill brought about? Before the securitization law came, that every person who takes large loans from the bank gives a security. Enforcement of that security is the essence of the securitization law. Earlier the law was, the bank will move the court or the DRT. The bank, having received the security, will still ask for attachment of that security. The debtor will keep running and the creditor will keep chasing him. The NPAs, because of this principle, in the year 2002 had touched 13%, much worse than the present situation. I recollect this because I was the law minister at that time and there was a big debate whether this law is constitutionally valid or not. In 2002, we came out with the securitization law and reversed this cat and mouse game. The bank will give a section 13 notice, take possession of the security, throw you out of the property. Now you go to court to show why the bank is not entitled to take this property. This was challenged, but for that clarification on section 13, the Supreme Court in Bharatiya Chemicals upheld the validity of this law. So this was the change in this whole culture. And from 13%, thanks to the securitization law, the NPS came down to 2 to 3%. Because now there was a danger of the banks re-entering your factory, plant, machinery, offices and homes. And that is when people started paying the banks back. Today, because of various factors, again the NPAs are rising. What does the bank do with this property? The banks would ask the asset reconstruction company to come in, take possession of the property, run the factory. The ARC only gets a transient and temporary possession. And after establishing it, it would then sell it off to a third person who would eventually become the owner, and the money received will go back to the bank being paid as the dues. Now, you rightly mentioned that currently there are very few ARCs because we have a tight regulated law. Now, to enable the establishment of more ARCs, all these liberalization in the ARC procedure which is being done, the RBI has to regulate so that you don't have any fake just property agents coming in as ARCs. So the regulation would be required, and RBI is a responsible regulator. But then you would also allow FDI so that people with assets, far deeper pockets also come up, set up ARCs. Transiently they take possession, and then the defaulter loses control, and a new person is asked to come in so that the factory can continue, the offices can continue, jobs can be saved, taxes can be saved, and the banks can be repaid back. The Stamp Act amendment is that you will only be adding cost to this whole process if you ask him that for this transient possession he pays stamp duty also. So that will be a disincentive. So that's the waiver which we are giving. And therefore, all these liberalizations which we have done are really intended in that direction. Just one last question which was raised in context of Tamil Nadu. Whenever natural calamities take place like floods, etc., then banks also have a humane attitude. They don't say that just because there is a flood in the factory we'll declare you an NPA. Then they extend that period, which was also being extended in cases of various natural calamities, including in Tamil Nadu, and a reasonable view is taken. There are higher NPAs as far as students are concerned, but then these are all areas where banks are supporting students to get educated. It's the responsibility of the students when they start earning to repay back. And I think in cases some more time is granted, an element of compassion will have to be seen in the context of this factor. You can't waive off the loan. Somebody has to pay for that loan. And eventually some more time is given. The banks would give that kind of a time, even though the NPAs in that category are a little higher at the moment. So the object overall of these two amendments is that you empower the banking system legally and expeditiously to be in a position to get those monies back. There is a public interest in giving loans. There is a public interest in those loans being serviced. And there is a public interest that those who default, there is an adequate mechanism to recover the monies from them. So I think all these three factors are in public interest. So far, the system has remained lopsided in favor of the defaulter. These bills tend to correct that balance, and I commend these bills for acceptance to the House. Regarding my friend Jairam's issue which he has raised, I'll certainly look into that issue, and if any clarification in the rules is required either in 32 or 36, I'll certainly have it looked into.
On tightening the system in favor of the banks, I'm fully with you, but 32 and 36 do provide some element of discretion in favor of the defaulter, and I would request you to have a relook at that.
Okay, thank you. The question is that Enforcement of Security Interest and Recovery of Debt Laws and Miscellaneous Provisions Amendment Bill 2016 as passed by Lok Sabha be taken into consideration. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. The motion is adopted. We shall now take up clause by clause consideration of the bill. Clauses 2 and 3 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clauses 2 and 3 are adopted. Clause 4 stands part of the bill. There is one amendment, number 1 by Shri Dr. T. Subramanian Reddy. Are you moving?
No, sir, I am satisfied with the reply. I will not move.
Thank you. Amendment not moved. I shall now put clause 4 to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clause 4 is adopted. Clause 5 stands part of the bill. There is one amendment, number 2 by Dr. T. Subramanian Reddy. Are you moving?
No, sir, I am satisfied with the reply. I will not move this.
Yeah, thank you. Not moved. I shall now put clause 5 to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have it. Clause 5 is adopted. Clause 6 and 7 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clauses 6 and 7 are adopted. Clause 8 stand part of the bill. There is one amendment, number 3 by Dr. T. Subramanian Reddy. Are you moving?
I am not moving, sir.
Yes, thank you. Amendment not moved. I shall now put clause 8 to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clause 8 is adopted. Clause 9 to 11 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clauses 9 and 11 are adopted. Clause 12 stand part of the bill. There are 3 amendments. Numbers 4 to 6 by Dr. T. Subramanian Reddy. Are you moving?
I am satisfied with the reply of the minister. I am
so not moving. Thank you. He has not moved the amendment. I shall now put clause 12 to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clause 12 is adopted. Clause 13 to 17 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clauses 13 to 17 are adopted. Clause 18 stand part of the bill. There is one amendment, number 7 by Dr. T. Subramanian Reddy.
Sir, here I would like to say the central government, as far as practical, shall implement regulations in expeditious and timely manner for the linkage of the central registry with the information utilities. So this amendment, I am not.
Are you moving?
Please, sir. It's only advisory to the Honorable Finance Minister. You can bear in mind this. That's all. My support.
So not moving.
Not moving.
Thank you. Amendment not moved. I shall now put clause 18 to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clause 18 is adopted. Clauses 19 to 43 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clauses 19 to 43 are adopted. Clause 44 stands part of the bill. There is one amendment, number 8 by Dr. T. Subramanian Reddy.
Yes, sir. Restricting the exemption only for the purpose of acquisition of financial assets by assets reconstruction company for assets reconstruction of securitization. Okay. This also suggestion to the finance minister. Not moving. Just suggestion.
Okay, not moved. I shall now put clause 44 to vote. Those in favor, please say aye. Those against, please say no. I think the ayes have, the ayes have, the ayes have. Clause 44 is adopted. The first schedule and the second schedule stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. The first schedule and second schedule are adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and title are adopted. Shri Arun Jaitley to move that the bill be passed.
Move that the bill be passed.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill is passed.